Breaking news a free high court by in the Wontumi Samreboi case say someone attached and a lawyer say asam no judge we transfer ye there be Wontumi ruling on the 20th of July 2026 exclusively all the 50 pages of the written statement as someone attached at the court no ye intercepted ruling no the 20th of July attached raise constitutional matters say hey judge unim na do saka case no Supreme Court to be now on refer certain part of the issue no to the Supreme Court. Is there a delayed tactics? Then American. Is there a delayed tactics? Is it say you ran the appeal could be a way case in now and again, it's a touch sure about the Nemano Canana, I'm a lawyer. But what are the constitutional issues Atakia is raising? Why does he want the judge to stay the judgment on July 20 after so file the written statement? A bit of law and a law pa me home family send me kaba mesremo and the no from fenche mesro say ye be this uncommon in this video. And make sure also be subscribe. Most subscriber no click the notification. Me the video be to be who know it we are. You have a comment free. Leave that comment in the comment section. We are. Make sure so be Goldberry construction method and episodes in assassin crata some the documentations related to your house in the Goldberry in the BDC Judgement na at the amount we are bring pomba or addiction related to trauma related to aged care. Or bring pomba show na be kama. Now give me about 5 minutes to build a background for you so that you understand what Samuel Atta Akyea is doing. Abai ede Wontumi in the Samreboi case and at the court. Now the case is largely about say Wontumi near contaminating and will legally acquired concessioner as well the mining. Now subsequently Samreboi for by agitation near the say illegal mining cost near there. The brief of the matter is that omoko tunkrofobia na yedwo Wontumi asase so. When those people were arrested and also when police did private investigations when near there no. Nkrofone can say Wontumi na abo mo pa so monya de no moye no asase so no. That is the testimony they gave. In fact, they testify for the state. Wontumi so asem obeka ye ne say there be minimum media me catch so monkoye reclamation because Samreboi for nkrofobia na tutu asase na China phobia. In fact, me Wontumi me your mind penti me throw letter I command the Western Regional Security Council the RECSEC say China for come asase so ento monko koma me. In fact eno ka ho ana Wontumi kofa yewra da komensa the former Western Regional Minister say wo media dance ye man again Wontumi san kofa mrekuduka any engineer referring wisdom gomashi dentia because section 14 of the Minerals and Other Offences Act no eka say Minerals and Mining Act 2006 ne ka say legally binding concession embrem ya ma wasase se fedi djuma fair mining na ukofa obi a ono yen license no nobody djuma bia wasase ne so a wato aban mra ana nkrofo ne kan se dabi the fact say me more legally assigned concession no I don't have the means to check say nipa no ba no ni license ana so license it is our responsibility ne dey odi to Wontumi so a enye yie ana Wontumi so kan ana ban kan se dabi emra ne se ne yete yes sana ne de wo kofa nipa na bedi djuma wo wasase so no wona so make sure say nipa no ne nkrata asem ne registration wa aban mu ne aban nkrata mu na eye korogen ene koye achi ne wahyew. Now about 1 month 3 weeks ago ana lawyer ndi apia kubi obia bonkro na wie. In fact attorney general bonkro na wie no Wontumi ne lawyer ka say ani attorney general ka nyinsem hunu to the highest level among kasa into among court akwaji be friend submission of no case high court and tentam and the court appeals court member appeals court ruling no a 31 page there's something there me linking it to some American and appeals court can say debi otie asam na attorney general provide no and 6 counts e dey abo Wontumi. In fact count no mo dey bo Wontumi no 1 was on the count of illegal mining any other account and here 6 otie ni nyina Wontumi wo question bia and questions are also answer it won't be any defense and ofre nipa be 4 mekai ofre former deputy minister mekuduka meka ofre Western Regional Minister former ofre engineer Gomashi and other people and omu nyina nso bo mu case wie tie dia adwen say ya wie abai manta go na ndepia because wa awro ne nsa efre Wontumi case no ho Wontumi nko no nko follow ya foforo because odwen say nsem bi aje ne keka niema bi o rezi aje ne ma na adwen odwen say aje na fa Wontumi ho tirimuka twi no mo fencha me wa fa Wontumi to pese jeli no jeli Wontumi to de wajana ma no saa de na ade che ya na e bete se lawyer Atta Akyea fa case no na okoka kire ne se written statement there Supreme Court elu ze enye nhye ba me sere me pese me ye ma me mere na me nhwem ana court ne man rent ga ruling e ba the 3rd of July na court ne ka se 14th omon file written submission no so the ruling na ka 3rd July no e ko 20th Ghana for bebre ani anye na me ka kire mo se judge no mo ma ne kwan because a criminal matter Wontumi to go jail to on man on the right window to ventilate his views and everything. Then the written statement about 50 pages. I certainly cannot take you through the 50 pages. I don't have the strength to do that. But there are relevant portions that I would like to read for your perusal. I'll quickly take you to where already constitutional matters or some judge and suspend the case. Now let me take you there quickly so that we can be able to do the analysis. Okay, page 9 already issues not say. Accordingly, pursuant to Article 132 of the 1992 Constitution, we pray that your Lordship to stay the delivery of the judgment and refer the following genuine constitutional issues for determination at the Supreme Court. Now, what does Article 132 says? So, I'm going to say a bit of law. So, let's do the legal analysis here. And the lawyers on the channel can also help me do the analysis. Now, I'll say Article 130, and in the subject to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedom, as provided in Article 33 of this Constitution, the Supreme Court shall exercise the exclusive original jurisdiction in all matters relating to the enforcement or interpretation of the Constitution. All matters arising as to whether an enactment was made in the excess of the powers conferred on Parliament or by any other authority or person by law or under this Constitution. Nti Samreboi Akyea ka se eba mrem se chinwahyew mre bi hu se chinwahyew ba bibia hu se pese ete Constitution ase yakwaji nkyiremu a the only person and answer only entity obetime di se adwuma no the Supreme Court say shall mandam so say the Supreme Court shall have the exclusive original jurisdiction. In the High Court in TBBS, Appeals Court in TBBS, Magistrate in TBBS, Secretary in TBBS, the only court that have the original jurisdiction to enforce and interpret the Constitution is the Supreme Court. Atta Akyea say, Oja 132 no so aka kire court no say onya nema mensa we one whether or not a true and proper interpretation of Article 1911 of the Constitution of 1992, Section 14(1) of the Minerals and Mining Act 2007 is legally vague, overbroad, and inconsistent with the letter and spirit of the said article, and therefore unconstitutional, null and void. Atta Akyea say Article 14(1) of 2006 Minerals and Mining Act no too vague. Yakase bibi vague and nti ase wachire eye overbroad as yama na ekokrokododo again osan say what legally inconsistent. It is Supreme Court to make chire. What is an Article 14(1) yebekoso 2 or say whether or not on a true and proper interpretation of Article 1911 of the 1992 Constitution, sections 92 99 2b of the Minerals and Mining Act 2006 as amended by Section 3 of the Minerals and Mining Act 2019, Act 995, is legally overbroad and inconsistent with the letter and spirit of the said article, and therefore unconstitutional, null and void. And whether or not on a true and proper interpretation of Article 1911 of the 1992 Constitution, the charges in count 4 and 6 against Wontumi and Akonta Mining, which were found solely on Section 99 2b of the Minerals and Mining Act 2000 and Act 703 as amended by Section 3 of the Minerals and Mining Act 2019, are inconsistent with the letter and spirit of the said article and therefore unconstitutional, null and void. Now let's pick the matters one by one. Now when you go to the Minerals and Mining Act, your two verses, your 2006 there, and then I 703. And at 2019, about President Akufo-Addo ban illegal mining, Galamsey bejentre han omo ko miam ranim. And only ebenya the amended version, Act 995 2019. Now, when you go to the 14, let me quickly take you there. When you go to the 14, this is what you find. Just a second. Just a second. Enya ha na be freezy o. My heat say na be freezy. Just a second. Let me just get it for you. Okay, it's here. It's here. Pardon me. 14 in here. Or say, a mining right shall not in whole or in part be transferred, assigned, mortgaged, or otherwise incumbent or dealt in a manner without the prior approval in writing of the minister, which approval shall not be unreasonably withheld or given subject to unreasonable conditions. Into a case, Section 41 of the Criminal Act says, you must write to the Lands and Natural Resources Minister. Na minister no in writing, na minister name our approval. It is a minister name our approval, then we be any illegal. Someone attach here say, sa interpretation and our wording of this no a vague, a legally inconsistent, a overbroad, because when you read Article 1911, let's go to the 1911. It's here. Or say, no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it is prescribed in a written law. Attach as 14 there's no prescribed punishment in law when it comes to when you breach the 14th one. That's what Atta is saying. There's something that happened in the submission of no case. You follow me. That's what Atta is saying. Now, two, Atta was who says in the letter say, now 92B, you know, let's go there. 99-2B. Where is it? Oh, where is this thing? Ayrame. Pardon me. Yes. Or say 99-2B of the Minerals and Mining Act is also vague, and that a true interpretation of that would mean that there's no prescribed punishment there. Now let's go to the 99-2B. Let me read for you the 2006 one. This is the 2006 one. This is what he said. It says that a person who acts in contravention of provision of this act in respect of which an offense has not been specified commits an offense and is liable on summary conviction to a minimum fine of 1,000 penalty units or to imprisonment for a term not more than 3 years or to both. And that's a 2006. Atta Galamsey any major issue no. Now yes, I will put some way so Galamsey, meaning say you contravene all the sections of the Minerals and Mining Act, or them 3 years. Now Atta Galamsey be gentle and ya amend the 995. Now look at the tone of the 995. The same 99-2B. No. Look at the tone. Or say any person or a person who acts, instigate, commands, counsel, procure, solicit, or in any manner purposely aids, facilitates, encourages, or promotes any act in contravention of the provision of this act in respect of which a penalty has not been prescribed or seen in family. But here sentence in here or say there's a sentence. The sentence is the 15 years to 25 years. That's the sentence. 15 years to 25 years. So if the person, for example, and this is it, not more than 15,000 penalty units or prison term not less than 15 years and not more than 25 years. So this is where the 15 years and 25 years come. So Atta Akyea is saying that the county edible Wontumi any specific terms. But when that matter was raised in the matter of no submission, the judge said something in that matter. And I'd like us to read what the judge said. Because Atta Akyea could be raised those matters when they filed for the submission of no case. This is what he said. Now let me clear for you what the judge said. That document is a 31-page document. This is the ruling of the judge, the appeals court level, when Wontumi filed the submission of no case. And this is what the judge says that this element relate to only count 4, 5, and 6 on the offense of purposely abetting an unlicensed mining activity, contrary to sections 99-2B of the Minerals and Mining Act 2006, Act 703, as amended by section 3 of the Minerals and Mining Act 2019. As found above, PW2, now say public witness 2, reclamation exercise constitute a contravention of section 59 of Act 703. Act 703, however, prescribes no penalty for a failure by a person to register or obtain a license or concession before providing a mine support service to a mine holder. Therefore, PW2's reclamation exercise satisfies this essential element of the offenses under 99-2B of 703 as amended. Tieniyo. So when counsel for Wontumi at the submission of no case level raise this same matter, say, oh, read this section 59, say, obi be adwuma ma obi a woro concession on register and the company na sentence and ye de kobo nipa na concession ye ne dia no na penalty bi eni ho no ana judge ne kan say penalty ni ho dia because of the amended version of 992B of 995 which amended 703 of 2006 no sa offense na ya under 9925 no should be used for 14(1) and 59. But what you say? Or see, therefore, PW2's reclamation exercise satisfies this essential element of the offense under section 992B of Act 703 as amended. And the 992B is what I read for you. Let me read it again for you. It's very, very broad. Because 2019, na Galamsey no abejentre ha into no musro. That is when they decided to broaden the scope of Sa Adeno. Now let me get it for you. This is the 992B. 995 na make and then 90 and then 703. 995 no say any person who acts, instigates, commands, counsels, procures, solicits. So going to bring somebody to work on reclamation, you have procured the services of that person. It suffices. That is what the judge said in the submission of no case. Someone Atta Akyea disagrees and says that the Supreme Court should come and interpret. But in 2019, when they were amending this by an act of parliament, Mr. Atta Akyea was in parliament. So that's also very interesting. And if indeed they didn't agree, because, okay, you can't blame Atta Akyea because our time, submission of no case ruling, but no one cancelled to Wontumi. So maybe he has also gone through the case and realized that this thing is there. So forget the law. The conclusion of everything is that offense near diabo Wontumi no ebi wo ho a ye ntro specific jail terms obeko 2 years obeko 2 years obeko 3 years ana Atta Akyea say sa de a e vague dia yenko Supreme Court yenko interpretation because article 1911 say no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it is prescribed in a written law. Patwati say. But means me you say to me lawyer, but my common sense understanding is that a written law includes an act of parliament, and the 992B prescribes that when you procure, instigate, whatever, solicit, you can go to prison for not less than 15 years and not more than 25 years. Me understanding. No, some Atta Akyea said they want chances at Enco Court, and I make catcher say when counsel for Wontumi then a bro raises submission of no case, you are and the appeal could be no. The judge ruled that if 59, section 59 and 14(1) doesn't have prescribed punishment, 59 talks about giving, allowing somebody without license to work. 14(1) says that you giving part of your legally acquired concession to someone to work on. Say ni prescribed and defined penalty. Send your 1911 cow constitution it suffices to use 992B because that covers almost everything. That is the contention now. So whether the judge will rule and delegate that to the Supreme Court, or the judge will also say that, or explain and the market and say the judge in the submission of no case said that 959 and 14(1) punishment can be found in 992B. I don't know. I'm not a lawyer. This is you say to choose critical analysis. Feel free share in the comment section. What's your say, mami? What's your say, mami? Oh, addition means to fabra. Again, me can be a man cancer Wontumi a cronfo. Na me can be a mesremo and mamo famenko. Mrana na machichi me court document. Make sure also be subscribe. I'm subscribe no click the notification. The video be to be hu no bet my share. Make sure also be show you the mama me hian Ghana so hian. Bye bye.